Good afternoon, everyone. Welcome to another webinar in the ongoing webinar series that firm, Garfunkel Wild PC, has been conducting in order to help out New York, New Jersey, and Connecticut clients and prospective clients deal with the difficult challenges posed by the outbreak of the COVID-19 virus. My name is Andrew Zwirling, and I'm here today with my partner, Roy Breitenbach, in presenting today's session entitled The Enforceability of Employment Contracts During the COVID-19 Pandemic. Very briefly, for those unfamiliar with our firm, Garfunkel Wild is a full-service law firm with more than 85 attorneys serving clients in New York, New Jersey, and Connecticut that will be turning 40 years old actually this month. Relevant to today's program, our firm has a very active and sizable employment law practice group that attends to our clients' needs in the tri-state area, including through today's program. Roy and I are partners in the firm's employment law as well as litigation practice groups, which gives us a fairly unique perspective as employment lawyers. Roy and I litigate and try cases, and we do that. We act an opportunity in a litigation to see how a client handled the situation rightly or wrongly, and then we use that information in our day-to-day employment law counseling function. In any event, with regard to today's subject, among the many impacts of the coronavirus pandemic has been what Roy and I have experienced for weeks now, a steep rise in concern over the viability of employment contracts. Businesses of all types in all industries, healthcare and otherwise, have experienced financial disruption of profound magnitude that's compelled them to take action of various types that, on their face, violate the plain language of employment contracts of which they are part. We've seen salary reductions, work reductions, terminations without the requisite notice in a contract, job furloughs, and similar actions that, on their face, seemingly violate contract obligations, and they've become fairly commonplace as businesses try to stay viable, if not operationally functional, during the crisis. And this raises obvious questions. Despite running afoul of the plain language in employment contracts, are such actions nonetheless proper given the impact of the pandemic? Are parties obligated to perform their obligations under employment contracts given the constraints imposed by governmental orders and other fallout from the pandemic, or are they discharged from those obligations? Does it matter if you have a force majeure provision in your contract? What happens if you don't have a force majeure provision in your contract? And today's webinar, Roy and I are hoping to accomplish is to address these issues and others, including the applicability of the doctrines of impossibility of performance, impracticability of performance, and frustration of performance, and the effect of force majeure clauses. And our goal is to assist you in navigating what many would agree is a pretty difficult landscape, and to explain some of the guiding principles relating to this situation. Just a couple of logistical issues before we move forward with substance. As true with our other webinars, and with regard to questions you may have, you can write them to us, and we'll do our best to answer them during the program. Please recognize, however, that there's a lot of material Roy and I have to cover, and we may not get a chance to answer all questions that are posed to us. But as we've done with the webinars that we've been putting on as a firm for many weeks now, you can always write to Roy and me, and we can set up a time to speak with you by telephone to answer any questions that may have gone unanswered in this program. Finally, the audio webinar and the slide presentation will be made available and provided to everyone who is attending either later this afternoon or the latest tomorrow. Okay. All right. Let's just move. Okay. The basic framework we're going to operate in for illustrative purposes is Executive Order 202.25. Now, it's a New York State executive order, and if you're sitting in Connecticut and New Jersey, you're saying, what relevance does it have to me? But the analysis that Roy and I are going to undertake in this session apply equally under New Jersey and Connecticut law. But we're just going to focus on one particular order. Just will facilitate our discussion and analysis as we work forward. So, Executive Order 202.25, just by way of quick backdrop, the initial executive order was March 7, 2020. And it essentially stated, and there were some specifics attendant to it, but in general form, it said that all general hospitals, ambulatory surgery centers, office-based surgery practices, diagnostic and treatment centers were required to cancel all elective surgery procedures. So that's March 7th. Fast forward, there was some light at the end of the tunnel with regard to the reopening concerning elective procedures, and to a certain extent that happened in New York as of April 29th, 2020, where that order was modified, basically opening up the ability to do elective procedures in over 35 counties throughout the state. But importantly, a number of exceptions or carve-outs. And the executive order expressly excluded from its scope ASCs, office-based surgery practice, D&T centers, and so on, as well as hospitals in New York City, Nassau, Suffolk, Westchester, Putnam, Rockland, and Orange County. So then the issue becomes, what is the impact of this order, which for those carve-out entities now dates back almost 2 months, and even with regard to the entities located in the 35 eligible counties, focusing on the time frame between March 7th and April 29th, what is the impact on employment contracts that those entities, hospitals and the like, have? You know, what is the obligation with regard to performance by either the clinicians or the employer? And that's going to be our framework moving forward as Roy and I discuss force majeure clauses and the doctrines of impossibility, impracticability, and frustration of purpose. The interplay between those doctrines, and I'll just simply say the executive order and its ban on elective procedures. With that said, Roy, next slide.
Okay, so I'm going to talk to you about force majeure provisions generally. As Andy said, the focus of this webinar is on force majeure provisions, right? Contracts often contain what are known as force majeure provisions. And they are provisions that recognize that there may be certain events that render one party or the other unable to perform its contractual obligations, okay? These events are outside the party's control and make performance of the contract impossible or impracticable or frustrate the purpose of the contract. And so the parties to the contract negotiate a specific clause to deal with what happens when those unforeseen events occur, okay? And they set forth in their contract what parties should do when those unforeseen events do occur. And if your contract has such a clause, that's what governs when one of these events occur. And it's really within the ability of the parties to determine, if they have such a clause, what they want to happen when this occurs, okay? So all 3 states, New York, Connecticut, New Jersey, will say that if it's in the contract, what to do if the event occurs, that's what controls, okay? So that's an important point. So if you have a force majeure clause, that's what controls. The problem, as we'll talk about later, is that it's been pretty standard that employment contracts do not typically contain force majeure clauses for a variety of different reasons, which is why now in this current environment, when we're looking at employment contracts, we often have to fall back on the doctrines, as Andy mentioned, impossibility of performance, impracticability of performance, or frustration of purpose. But let's go through some issues regarding force majeure clauses in general in the beginning. It's important to realize that these clauses either can contain general descriptions of unforeseen events, such as acts of God, disturbances, or they can talk about specific events. Some may even include phrases such as pandemics or epidemic. In New York has a very restrictive view of force majeure clauses and says that a force majeure clause will not be triggered unless the specific event is mentioned. So for example, there's an argument to be made that if your force majeure clause does not mention pandemic in New York, can't claim that COVID-19 triggers the force majeure provision. Now, some cases do say in New York that if it contains language that says such as including but not limited to other acts of God or something like that, you may be able to argue that pandemic is included. But New York takes a very restrictive view. Your event has to be specifically set forth. The nature of that event, the type of that event has to be specifically set forth in the force majeure clause. And if it has a catch-all phrase such as any other events that are acts of God or any other events that may make performance impossible, you have to show that the event that you have is similar to the specifically listed triggering events in the clause. So again, New York takes a much more restrictive view than other states, both in New Jersey and certainly in Connecticut. If in fact the event is close to or similar to or reasonably analogous to the events that are actually in the clause, courts will say that the clause is triggered. So you have a lot more leeway in New Jersey and Connecticut than you do in New York, which is why if you want a force majeure provision to apply, as we'll talk about later, it's often preferable if you have the ability to choose the law, that you choose the law of a state other than New York. These force majeure clauses also often say that a party will be released from liability when there is a force majeure event, and often set forth notice provisions and other issues. Let's take a look at a standard force majeure provision. It says that neither party will be liable for, so it will excuse liability, or be considered in breach of or default under this agreement by reason of any failure or delay in the performance of its obligations on account of, and as a whole list of issues. Okay? Now, if you notice here, it does not say pandemic in this particular provision. Okay? It does, however, say at the end, or any other clause which is beyond the reasonable control of such party. So, arguably, pandemic would be a clause which is beyond the reasonable control of such party. And you could argue, if you saw this clause, that if you had this clause, that it would apply to a pandemic situation. New York law would, however, look at the various specific events here, strikes, shortages, riots, insurrections, and will look to see whether or not pandemic was reasonably analogous to some of these categories. In this clause, you could argue that a pandemic was an act of God. It's an unforeseen event that happens beyond the control of the parties. You might be able to argue that it slides under acts of God. Okay? It's important to recognize now, if this was in your employment contract, you may be able to use this, an employer, to say that as a result of the pandemic, the employer is excused of paying compensation under the employment agreement. Let's now go to the next slide. Here is a much more detailed force majeure provision. In this provision, as you will see, it's interesting. It carves out at the beginning, except for payment obligations. So what that essentially means is that you may have a force majeure provision, but the parties have agreed that payment obligations are excluded. So even if the force majeure event occurs, it does not allow a party to slide out of its payment obligations. So if this was the particular force majeure provision in an employment contract and you were the employer, all right, you could not use this clause to get out of delaying or not paying under the terms of the clause, because right at the beginning it carves out payment obligations. Then it says neither party will be liable under this agreement for any failure or delay of performance of its obligations hereunder, if performance was delayed or prevented by acts of God, fire, explosion, war, terrorism, and it goes on. So in this case, the pandemic might be considered an act of God. Certainly, if there was a closure order, it might fall under governmental laws or regulations. For example, if you were a practice or you performed elective surgery, you might argue that this clause because it excuses performance that are prevented as a result of governmental laws or regulations. It does apply, but again, if you're an employer and you are using this type of clause to try to say you don't have to pay your physician employee because of the pandemic, you're going to run right up against the first clause, which says except for payment obligations. And this is also the example of a clause that talks about what occurs when the event happens. It says, during the pendency of any force majeure event, the party affected will work diligently. So you have an obligation to work diligently to cure the event to the extent commercially reasonable. So you just can't call that there's an event and then do nothing. You have to work to try to resolve the event. And then, though, if the force majeure event continues for 30 consecutive days, the party that's not directly affected by it may terminate the agreement immediately without penalty. So there's an out clause. If the force majeure event occurs for 30 days, there's the ability to get out of the contract. Now I'm going to go to the next slide. Let's now look at what occurs when you have a force majeure clause. The first thing you need to do is you need to look at what the facts are. Okay, that's the absolute first thing to do. What are the facts that are happening? You need to review the contract as a whole to make sure that there is a force majeure provision. If there's not a force majeure provision, and as we've said, many employment contracts do not contain force majeure provisions. The reason being, we believe that from an employer standpoint, particularly in the healthcare field, the employer wants the employee to provide services during times of unforeseen emergency circumstances, because that's when the demand for healthcare services are the greatest. And if you're an employee, you want to make sure you have a job during those times. So as a result, it's pretty standard for employment contracts not to contain a force majeure provision. And if they do not contain a force majeure provision, then you have to rely on the doctrines of impossibility, impracticability, or frustration of purpose, which we'll talk about later. One of the most important things, as we've talked about, you have to consider when looking at force majeure clauses is what the applicable law is in the contract, what state's law applies. This is particularly important because, as we've explained, the different states have different laws. New York tends to be much more conservative and restrictive with regard to force majeure clauses, as opposed to Connecticut and New Jersey, which tend to be more expansive. So it's very important to understand what law applies before you start analyzing force majeure clauses. So let's now go to the next slide, which is how are force majeure provisions applied. As we've talked about, many courts apply a very narrow, restrictive approach. They always look to the express language of the provision and ask first, is the event specifically listed in the provision? As I've explained before, New York is very, very strict about this. If your triggering event is not one of the events listed in the provision, you will have a hard time contending that the force majeure provision applies. And even if you have a catch-all provision that says, or any other events which render performance impossible, you have to show in New York that your triggering event is similar in size and scope and nature to the events that are specifically listed in the clause. New Jersey takes a much broader view and will allow you to always show events that may not be specifically listed in the clause, but are similar or bear some relationship to, or have a degree of likeness to the clauses that are listed. Always you have to ask is, was the event beyond the reasonable control of the party? Because if you as a party cause the event, you can't contend that it triggers a force majeure provision. The entire concept of a force majeure provision is to deal with problems outside the control of the party. You also have to show whether or not the event was reasonably foreseeable at the time that the parties made the contract, because there's an argument to be made, and New York follows this pretty strictly, that if the event was reasonably foreseeable at the time that the contract was made, and the parties did not include the event in a force majeure clause, they were actually intending that the event that was reasonably foreseeable would not trigger a force majeure clause. So you have to be careful about that. You also have to ask whether there's any obligation under the clause for the party that's seeking to avoid performance to mitigate, to do something to prevent damage happening by as a result of the situation. For example, the clause may obligate you as an employer to go and negotiate with your employee in the event of a triggering event, to see if you can come up with a mutually satisfactory arrangement. It may require you to do everything in your power to overcome the event, okay? There also always has to be a direct causal link between the event and the material impact. What this essentially means is that COVID-19 is not a get out of jail free card. It does not enable you to get out of every employment agreement and every contract that you may have entered into. You have to show directly that COVID-19 or the governmental orders associated out of COVID-19 specifically prevented you from performing your obligations. There has to be a direct causal link. It's not a get out of jail free card. Finally, there always has to be timely notice. There always has to be some type of a notice that goes to the other side, usually in the terms of the contract, that lets everyone know that you're using a force majeure clause. Okay, COVID-19, let's now go to some specific COVID-19 analysis. It's absolutely a pandemic. So pandemic is on the list, or epidemic is on the list. You're good from a standpoint of COVID-19 being a triggering event. It absolutely was foreseeable. It absolutely was not foreseeable, arguably, if you entered into your contract, certainly before 2020. From this point forward, there's going to be an argument that pandemics are foreseeable. You have to ask, as I said, is there an ability to mitigate? Is your impossibility of performance directly due to COVID-19? You have to do a case-to-case, case-by-case analysis, looking at the specific. Going to the next slide, we've talked about this. It's classified as a pandemic by the WHO, coronavirus. It's also an epidemic. You also have the local states of emergency, and you also have government shutdowns, isolation, and quarantine. All of these may contribute to an argument that coronavirus is going to trigger your force majeure clause, but it's not automatic. In this particular case I cite here is a very interesting case. This is what I call the not a get out of jail free card. This happened after September 11th. September 11th happened obviously in September of 2001. In early 2002, there was going to be a conference in Hawaii for some business, and they were going to have people from all over the country travel to Hawaii for this conference. However, it became apparent to everybody by December of 2001 that the conference was not going to be well attended because people were afraid to travel by plane after September 11th. So the sponsors of the conference tried to cancel the conference and get out of it their obligation to pay the substantial cancellation fee to the resort by contending, well, there's a terrorism triggering event in the force majeure clause. So, hey, September 11th was a terrorist event. We're canceling because people are afraid to come because of terrorism. So therefore, we don't have to pay the cancellation fee. And the court rejected this argument, saying that, no, you can't show, you had to show a direct relationship between a terrorist act and the prevention of your honoring your obligation. That's not what happened here. You're using something that happened months ago that caused some people, not all people, not to want to travel, and then you're using that to say that you're not going to make as much money as you could under the conference, and therefore you want to cancel it. And that just doesn't meet the direct link You just can't invoke September 11th or coronavirus and get out of every contractual obligation. You really have to have a clear pathway and a direct link. So let's now go to 11, and we're going to talk, Andy's going to talk about the impossibility of performance doctrine.
All right, as Roy mentioned earlier, it's not typical to have a force majeure clause in an employment contract. So then the issue becomes, well, I don't have a force majeure clause in my contract, or you have a force majeure provision that doesn't take into account the coronavirus. You don't have that catch-all phrase that one of the slides that you saw before, or any other unforeseen circumstance beyond the parties' control that renders performance impossible. And the short answer is that you don't have to have a force majeure clause to tap into some of the other doctrines Roy and I are going to describe. And one of those, that the first one we'll deal with, is impossibility of performance, okay? So what are some of the elements? And you're going to see a lot of overlap between these doctrines. They're subtly different, but there are, themes that weave throughout, whether it's a force majeure clause, impossibility, of frustration of purpose. So the event is unexpected, unanticipated, and unforeseen. You have to have an unexpected intervening event occur in order to trigger the application of this particular doctrine. Impossibility requires an unanticipated event that had not been foreseen or guarded against in the contract, and the defense is not available if the performance was rendered impossible by a foreseeable event that the could have addressed in their contract. And there's a reasonableness standard that goes with that. It's not anything conceivable that imagine might happen. There's a reasonable standard that attends to that. The event not guarded or protected against in the contract, no allocation of risks. The parties' agreement must have assumed that such an event would not occur. And the courts, when they look at the applicability of the impossibility doctrine, ask whether the non-occurrence of the event was a basic assumption on which that contract was made. And it ties into the foreseeability issue as well, using just a random example. If there was a civil war affecting the supply chain in a particular contract that was going on at the time the contract was entered into, and then ultimately that civil war impaired or affected the supply chain and prevented one of the parties from performing, well, that's something that could have been anticipated. That's something that could have been guarded against or referred to in the contract, and under those circumstances, the impossibility doctrine would not likely apply. And then finally, the event is responsible for making performance impossible, destroying the subject matter of the contract. Again, that ties into the language that Roy was referring to in your typical force majeure provision. All right. Definition, it's an objective standard. It's not the subjective beliefs or perceptions of one of the parties. It's what reasonable minds would agree constitutes an impediment to the performance of the contract. Kind of as Roy mentioned with regard to force majeure provisions, the party seeking to evoke impossibility could not have created the condition that led to impossibility. And again, just to reiterate and stress the important point here, impossibility shown where the event destroys the subject matter of the contract or the means of performance. So what does that mean? Narrowing it down to some more specifics. Possibility can occur when performance is prevented by an unforeseen change of law or governmental order, or as you'll see in the next slide, it could be an administrative order, it can be a court order, and it impairs or impedes the ability of one or both of the parties to perform. So as you can see, court orders barring the performance of the contract could be grounds for an impossibility if the party owing performance did not contribute to the issuance of the order. That taps into that provision on the earlier slide that says you cannot claim the applicability of this doctrine if your actions or your inactions gave rise to the conditions upon which your impossibility claim is based. Right? Contractual duty may also be discharged where performance is subsequently prevented or prohibited by an administrative order or by the need to comply with the rules of a governmental authority. And we're going to talk in a little bit more about some of the application of this specific doctrine to the COVID-19 situation. And again, the timing is critical, much in the way that you have with force majeure clauses. If a contract could be performed at the time of its formation, but subsequent action by the government made performance impossible by preventing supplies necessary for performance from being procured, or prevented the performance by one of the parties to the contract, the defense of impossibility may apply. Roy, some non-qualifying events?
Yes, I'm going to do that now. So here we go. So now there are some events that the case law has said are non-qualifying events. So let's take a look at some of them now. So generally, when you have an impossibility standard, impossibility does not apply simply when performance is more difficult or costly than anticipated, right? So because you have an event that triggers it and makes performance more costly or more difficult, that shouldn't be enough under an impossibility. It also generally can't be premised on financial hardship of the promisor, no matter how severe. So generally, under an impossibility of performance standard, just because performance is going to cause a financial hardship in and of itself is not going to get you out of your obligation to perform. So applying it in the context of employment contracts and COVID-19, just because now would be a financial hardship for an employee to pay the salary, that event alone under an impossibility of performance concept would not allow you to get out of your contractual obligation. You would have to show something else, a governmental order that prevented you from providing services or something like that. Just mere financial hardship standing alone is not enough under an impossibility of performance standard. Same thing, insolvency or inability to obtain financing does not create an impossibility standard. For example, not paying somebody's salary because you didn't get the PPP loan, that standing alone is not going to give you impossibility of performance. It has to get something more, something that's objectively impossible. Impossibility does not occur when performance is simply unprofitable or merely because it ceased the operation of an unprofitable business. It has to be generally for purposes of employment tax. It has to be something in the nature of there's a governmental order. I can't perform elective surgeries, so I'm paying you to perform elective surgeries. Now we can't provide elective surgeries. It's not the fact that I'm not getting any revenue. It's the fact that there's an unforeseen governmental order that's preventing me from paying you. So that's the kind of argument that you have to make. So now, not all states or all circumstances do impossibility of performance. Impossibility of performance is the standard in New York. It is not the standard in New Jersey, which is impracticability of performance. Although Connecticut doesn't say one way or the other, it's generally assumed in Connecticut, based upon the case law there, that it's impracticability of performance. So let's talk about impracticability of performance. Impracticability of performance is a lower standard than impossibility of performance. You first have to show that the event is unforeseen, and that's not the fault of the party seeking to be excused. And then you have to show that the event makes performance impracticable, not totally impossible, but impracticable. That generally occurs by showing that the non-occurrence of the event was a basic assumption on which the contract was made. Applying this directly to COVID-19 and employment agreements, when you entered into your employment agreement to pay that surgeon, $5,000 a day or whatever you paid that surgeon, a basic assumption of that agreement, I would argue, was that you were going to be allowed by the government to perform elective surgeries. Now you're not. That's not occurrence of an event that was a basic assumption on which the contract was made. So that is a good way of arguing impracticability of performance. If you go through that analysis with a lot of other provisions, you will see that it is easier to argue impracticability than impossibility. So if you have an impracticability standard that applies in your force majeure clause, if you're in New Jersey or Connecticut, states that follow impracticability, you have a much easier time of trying to get out of a contractual obligation. The general standard is you can show extreme, exceptional, or unreasonable difficulty and expense. That will trigger your ability to get out of or slide out of performance because of impracticability. So again, it's a much more legal standard. So now I'm going to turn it over to Andy to talk about frustration of purpose.
Okay. The last doctrine that Roy and I are going to talk about before talking in a more analytical manner about the interplay between these doctrines and the restriction on elective procedures is frustration of purpose doctrine. And this occurs when both parties can perform, but as a result of unforeseeable events, the performance by one party would no longer give the other what induced the other party to make the first place. It's, again, you're seeing same phrasing interwoven between these different doctrines. It also requires a wholly unforeseeable event that renders the contract either valueless or substantially valueless to one party. As true with the doctrine of impracticability, it's a lower standard than impossibility. Here, both parties can perform, but an unforeseen event that couldn't be foreseen and beyond the party's control undermined the purpose of one or both of the parties in entering into the contract in the first place, where it leads to a result where the contract has no value or grossly diminished value to one of the parties. So to use a simple example, you have a wedding contract. Parties agree they're going to have a wedding at the Smith location with 200 guests, and all of a sudden there's a governmental order saying that venues can only operate at 50% capacity, or you can't have public gatherings more than 10 people. Is it possible to have that? Yes, it's possible. So the impossibility doctrine would not likely apply under these circumstances. Does it, render it impracticable? Arguably, yes, but certainly is the purpose of that contract, diminished substantially, not entirely as a result of those governmental orders? Yes. So again, a simple example of the applicability of the frustration of purpose doctrine. A few caveats to this doctrine. A party can't rely on it if it receives substantially what it bargained for under the contract. The fact, and this is similar to the impossibility doctrine and impracticability doctrines, the mere fact that the occurrence of the event has made performance more onerous or more costly does not mean that a frustration of purpose has occurred. It's not enough that the transaction has become less profitable for the affected party, or even that it would result in a loss. That's not sufficient to implicate frustration of purpose doctrine. And again, the frustrated purpose must have been so completely the basis of the contract that, as both parties understood, without it, the transaction would have made little sense. All right, so how do we apply these doctrines, impossibility, impracticability, frustration of purpose, to the current landscape? Focusing on the executive order in New York that from March 7th through the present time to certain entities throughout the state, and even from March 7th through April 29th for all entities throughout the state, has barred the performance of elective procedures. And arguably, one, two, or three of these doctrines, they all apply. Working through the various elements of those doctrines with regard to elective procedures, well, unless one is going to violate the law, it's not possible in New York City to perform, just by way of example, an elective procedure. Is there frustration of purpose? Yes. That you hire, for example, an anesthesiologist to provide anesthesia services at your ASC, but your ASC is essentially shut down because of a governmental order prohibiting the performance of elective procedures. Well, the very purpose of that contract with the anesthesia practice was to provide anesthesia services during the very procedures that are now barred. It doesn't you go out on a short limb to say that the purpose of the practice of the ASC, I should say, in entering into that contract has been rendered valueless or substantially valueless. So there's a pretty strong argument that the frustration of purpose doctrine applies in these particular circumstances. Additionally, walking through the overlapping elements, the COVID-19 virus likely was not something that could have been foreseen by the parties unless they entered into their contract, on March the 7th or 8th or somewhere in a more recent time frame. It was certainly unusual and unanticipated at the time when most contracts were signed, which has put people in this position. So there's strong support for the conclusion that these doctrines do apply with respect to the enforceability of employment contracts, relating, to elective. Could be an employment contract, a doctor who is, going to perform an endoscopy, for example, at an ASC. I'm just focusing on illustrative examples. And there's strong parallel support that one can find, even issued by the Department of Labor, that supports the conclusion that these doctrines would apply under these circumstances, and that the elements of foreseeability and so on, and the element that it must be beyond the control of the parties, are supported, under the facts that we're living through today. And specifically what I'm referring to has to do with the reference to the WARN Act. For those unfamiliar with the WARN Act, which is the Worker Adjustment and Retraining Notification Act, the WARN Act requires employers with 100 or more full-time employees, and I'm speaking in general terms, to provide at least 60 calendar days of written notice under federal law of a work site closing affecting 50 or more employees. And there's certain other criteria, but the basic gist is if you're an employer of certain magnitude and you're going to have a mass layoff of certain magnitude and meet certain other criteria, you have to give 60 days notice under federal law. And individual states have, different forms of notice. For example, New York, it's 90 days notice. And there are severe financial penalties if an employer who's going to engage in mass layoffs fails to follow the terms of the WARN Act. But there are exceptions to that notice requirement of the WARN Act, one being what's called the unusual business circumstances exception. And the unforeseeable business circumstances exception applies to mass layoffs caused by business circumstances that were not reasonably foreseeable at the time that the 60-day notice would have been required. And similar to the analysis that Roy and I are going through, underlying the doctrines of impossibility and frustration of purpose and impracticability, under the WARN exception, that unforeseeable business exception, an important indicator of a business that is not reasonably foreseeable is circumstances caused by sudden, dramatic, and unexpected action or condition outside the employer's control. And one of the examples given in the applicable regs is a government-ordered closing of an employment site that occurs without prior notice, also may be an unforeseeable business circumstance. That sounds familiar because it is, very much similar to what Roy and I are describing, is the predicate for, relying on one of the doctrines that we've walked through. And the test for determining when that business circumstance exception may apply, or when business circumstances are not reasonably foreseeable, focuses on an employee's business judgment. And employers under those circumstances are not required to accurately predict the future, much in an employer in our context in this session was not required to do so. And notably, as a sign that the COVID-19 outbreak constitutes such an unforeseeable business circumstance, the Department of Labor has expressly recommended that employers review that particular exception to the 60-day notice requirement. The Department of Labor is not saying it necessarily applies because it depends upon the particular fact affecting that employer, but it's telling them, take a look at this, suggesting that the strict enforcement of that notice requirement that generally would occur may be loosened under these circumstances. So why did I go on that quick concerning the WARN Act? Because likewise here, there is a compelling argument that the coronavirus, issues, specifically the governmental is ban the performance of elected leaders, as we've described, constitutes, the type of unforeseeable, unanticipated event that would now give rise to, viable arguments under the impossibility doctrine, the impracticability doctrine, the frustration of performance doctrine. So with that said, then what happens to that contract? What happens to some of the obligations that, parties have under these contracts? Well, for example, if physicians are not working in these because they can't perform elective procedures, obviously what the compelling argument exists that you don't have to be paid to do nothing. The performance of that contract has been rendered impossible unless you violate the law. If the purpose was to perform elective surgeries, well, clearly that purpose has been frustrated. And therefore, the parties are discharged from their obligations because of that. It's not parties terminating. It's not that one party's in breach. They are simply discharged from their obligations. And that opens the door to such outcomes as either terminations, furloughs, pay reductions, hour reductions, and so on. Also correlates to what Roy had described earlier. It's a form of mitigation on some level, but it's also just, dealing with reality, as it comes. So, for example, if an ASC is essentially shut down, I'll use a hospital as a better example for the point I'm trying to make. A hospital can no longer perform elective procedures, but its ICU operating at full steam to deal with coronavirus. A hospital has a compelling argument that, given the circumstances, one of the things applies, and in a contract with a doctor who is otherwise performing elective procedures is no longer enforceable. The parties are discharged from their obligations. You can terminate, you can furlough, maybe reduce pay, or you can ask the physician to move to provide other services, maybe help out in the ICU. Maybe the physician declines, maybe the physician says yes. But at the end of the day, the underlying contract would no longer be enforceable given the applicability of those particular doctrines. So that then gives rise to other ancillary issues, maybe significant issues. What is the impact of the crisis on the enforceability of restrictive covenants in contracts? And the answer is, with all the applicability of all of these doctrines, it's going to depend on the facts. And the answer to that question is that where impossibility or practicability or frustration of performance excuses some future performance on the contract, it doesn't necessarily unwind the part of the deal that's already performed, nor does it necessarily excuse performance of tasks that are not impossible. So what do I mean by that? What are some of the factors that the court may look at in deciding whether or not a restrictive covenant in a contract, in an employment contract, is going to be enforced? Well, let's suppose you have a multi-year contract, a 3-year contract, and it was fully performed for 2 years and 10 months, and it's only been the last 2 months where the COVID crisis has prevented performance of the contract. That factor may weigh in favor of enforcing restrictive covenant. Operative word may. Flip it around. Let's say it's the contract that was signed as of February 1st, and the physician 2 months later all of a sudden finds himself or herself on the sidelines, unable to perform and terminated. I'm just using examples. So here's a physician who worked for 2 months before being terminated. Is the restrictive covenant enforceable against him or her when he or she did not get the substantial benefit of the bargain underneath the contract? So, these are factors that a court's going to look at in deciding whether to enforce that restrictive covenant. Another example may be, suppose a physician has been furloughed rather than terminated, or the physician simply his or her hours and is working at 50% capacity or 20% capacity, and then when the ban on elective procedures is lifted, up a time, not that anyone can predict it as of today, June, the ban is lifted throughout the state. So there was a roughly 3-month hiatus, and the physician goes on to perform under contract for another year or two, whatever the term may be. Is the restrictive covenant enforceable under those circumstances, where the contract was not wholly but substantially performed? An argument can be made, yes. But these are some of the open issues, and these are some of the factors that the court is going to take into account in assessing whether or not to enforce the right.
Sure. Okay, now we will go to the next section, which is talking about future, what's going to happen in the future, right? So, now that we've had this pandemic, okay, and we're moving forward to the future of contracts, what's going to happen with regard to how pandemics are looked upon in the future with regard to force majeure, the doctrines of impossibility and impracticability of performance, and frustration of purpose. As we talked about at the beginning, a basic premise of this whole conversation was that a pandemic such as COVID-19 was not foreseeable, reasonably foreseeable. And that's why it would trigger a force majeure clause, why it would trigger the doctrines of impossibility, impracticability of performance, or frustration of purpose. Well, since we've now gone through a pandemic and we've all been sitting at home or had our worlds upended for the last 2 months, a strong argument can be made from this point forward. Pandemics are not unforeseeable, they are foreseeable. And therefore, parties should specifically address how they want to deal with this situation in their contracts. Because if they don't address, then argument can be made that the parties specifically intended not to have a pandemic excuse performance. So if you think that there's any possibility or any doubt on this subject, now that pandemics are arguably foreseeable, it is vitally important to have a force majeure clause and include it in your force majeure clauses. Okay? And these clauses should specifically spell out how pandemics should be addressed. All right, let's go to the next provision. It says, the language that you should have now that we know about pandemics occurring should be dependent on the nature of the contract and the party's business. So you have to ask yourself, are you looking to excuse performance or expect performance when a force majeure event occurs? The type of clause you put into your contracts in the future are dependent upon which side of the spectrum that you are. If it's an employment contract and you're looking to make sure that your worker continues to work and doesn't leave you in a time of an emergency, well, then you want to draft the clause one way. If you're looking to have flexibility and not pay certain workers when there's a pandemic, you're going to draft the clause another way. So it's really dependent. The language of the clause is dependent upon what side of the street you're on with regard to this. And so what we're recommending all of our clients do as we go beyond this time is to review your contracts, document where you believe that there may be COVID-19 related issues with performance, document COVID-19 related issues with your current contracts, decide to provide proper notice if you enforce a force majeure or another doctrine, and attempt to mitigate if appropriate and possible, document that you made reasonable attempts to mitigate, demonstrate the lack of availability of other viable options. These are all things you should do, and you should analyze consequences. Okay. Now here's some specific recommendations you can look at with regard to future contracts. One thing is do you expand force majeure events? Do you describe an obligation to mitigate in your contracts? How much time? Should you require timely detailed notice? We think that it's in almost all circumstances, it's always preferable to have timely detailed notice before you're invoking a force majeure clause. Should you describe when performance will and will not be excused under a force majeure clause? This is very important, right? Because you want to know what the rules of the road are when you have a force majeure event. Should you specifically address, and you should, we believe, what obligations are not waived when a force majeure clause is triggered, so that everybody understands what you will and you will not do. And finally, as should be crystal clear as we've been talking about this, it is vitally important to understand the impact that a choice of law has on force majeure clauses, because some states are more conservative than other states. Another thing you hear around regarding force majeure clauses is the concept of business interruption insurance, right? You know, there is insurance out there that protects against business interruption. However, that insurance has a lot of exclusions, specifically pandemic-related exclusions, and it's the subject of some controversy now, as most of the business interruption insurers are not providing coverage. So you have to take into account the fact that you will not have insurance coverage at the time of future pandemics when deciding how to deal with force majeure issues. So that's a vital point. Here is a basic force majeure provision that we think makes a lot of sense to include in a contract. You can take a look at it. If you have any questions on it, you can ask us as we're getting close to 1 o'clock. So here, that's a basic provision. And now here's my bio. Andy's bio is here as well. If you wish to contact us with any future questions, let me go now. And let's see if there's any questions. Andy, are there any questions?
Yeah, I'm just looking through right here. What if a radiology practice is told more than half the doctors not to come to work without pay due to decreased volume? To answer that question, I'll say it this way: it's one example, a variation of a theme, where a particular practice is operating at 50% capacity because its elective procedures have been prohibited, and so, you know, the volume has gone down, and whether it's 80%, 50%, the amount does not necessarily matter, because it's going to affect each one of those physicians, you know, regardless. And so I'm not sure if the question's asking, is this a permitted practice or not? Again, just looking at the question, without pay, well, I guess here's the thing: if there's frustration of purpose or impossibility or impracticability, at that point the parties are discharged from their obligations. And so a physician can be asked to come in. The without pay part, I'm not sure if I'm understanding the question correctly. A person doesn't have to perform services without pay. The issue that we've seen many times over is where all of a sudden there's been a pay reduction of X percent, 50% or 80% because of you know, volume that is no longer there because of these governmental orders. You know, we haven't encountered a situation where someone's being told to work for free. You know, if you're staying at home and not providing services under those circumstances, yeah, you don't have to pay someone to sit home and do nothing, because again, circling back, you're discharged from your obligation as an employer, as an ASC, a hospital, and so on, of having to pay someone if they can no longer provide services due to these governmental orders. If that hasn't answered the question, again, feel free to reach out to Roy or myself by email, and we'll do our best to get back to you and get those questions answered. Roy?
I think there's one more question we should answer. That is, somebody asked whether governmental action counts for COVID-19. And I think that, yeah, the answer is yes. That force majeure clause that excludes governmental action, still argument made that the governmental action, the closure orders, the shutdowns are all, the ban on elective surgeries are all governmental actions that support a impossibility of performance or a force majeure trigger. I think it makes a lot of sense to rely on these. If that's probably the strongest basis, depending on how the clauses are worded. But again, as we've been saying, they're very fact specific, so it's important to review them carefully, review them with your legal counsel before you do anything. So I think that's all the questions we have time for. And again, as Andy said, if at any point in time you have any other specific questions that we haven't answered, we'd be more than happy to answer them. Just email us and we'll respond. And thank you, and have a nice day.
Otherwise, be safe and be well, everybody. Thank you.